Reprise du débat,
Resuming debate.
Member for Elmwood-Transcona.
Well, thank you, Mr. Speaker. I'd like to start my remarks today by first of all saying thank you to all the men and women who serve our country in the RCMP. It's been a real honor, frankly, Mr. Speaker, to have an opportunity by working on C7 to hear from them, to get a sense of what they think the needs and challenges of the RCMP today are. And it's something that, as a new member of Parliament, it's been an occasion for me to learn a lot about a very important institution here in Canada and to hear directly from those who serve us so well. It's been our attempt in the NDP to try and manifest that thanks in arguments and a position on C7 that we believe will bring about the best outcome for members of the RCMP and give them a greater say in the future of the institution that they serve, and through that institution serve the country. So it's my hope that our arguments and actions in this debate have been worthy of their service. And in that spirit, I'd like to make some remarks about the bill at third reading, Mr. Speaker. When we started out on C7, it was one of the first bills that this government brought to the House of Commons, and at that time, at least, Mr. Speaker, there was a collegial spirit and a lot of talk about the importance of the committee process and how empowered committees were going to be in order to make meaningful changes to legislation. At that time, there was far less evidence that may not have come to pass than I would say there is now. And so we were happy to support that bill at second reading, to send it to committee to deal with what we thought were some important concerns. Some of those concerns were addressed, and we were happy to work with other parties in order to get rid of clauses 40 and 42 from the bill, which really had little to do with the Supreme Court decision and was kind of tacking on a decision about members' benefits without the benefit of consulting them, and before, and frankly just before, or on the cusp of them potentially having a bargaining unit that could do that credibly on their behalf. So that didn't make sense, Mr. Speaker. We were very glad to work with the other parties on committee to jettison that part of the bill and leave it for later when RCMP members could be represented in that discussion and help come to a conclusion about the state of their own benefits rather than having that decision made for them. The next important area of concern from our point of view, Mr. Speaker, and from the point of view of, I have to say, nearly every RCMP member that's contacted me as the responsible critic in the NDP about this bill, are the exclusions. So we heard honourable members today talk about the kind of two important elements of the Supreme Court decision, the explicit ones, Mr. Speaker. Those are independence of the bargaining unit from management and choice, that members be able to choose who that bargaining agent is. I think what gets lost, even though those are the two explicitly mentioned items by the Supreme Court, is that you need to have an independent bargaining unit freely chosen by the membership in order to bargain with the employer about the things that matter in the workplace. So even if the bill meets those two aspects, Mr. Speaker, of independence and choice, if it leaves nothing to bargain, because that's all been excluded under the legislation, or if it doesn't leave most things to bargain, Mr. Speaker, then I don't think it's in keeping with the spirit of the Supreme Court decision. And I've said before in this House that I think the bill as it stands is certainly open to challenge. It's not just open to challenge because it's a bill, it's a piece of law, and it's open to challenge, and any bill at any time is open to any challenge. It's open to challenge and is likely to be challenged because it doesn't satisfy the people who went to court and fought for years in order to be able to get some meaningful say over the future of their workplace, Mr. Speaker. Not because by getting collective bargaining rights, all of a sudden employees or the president of the union or just anyone who happens to work for the RCMP can walk into the commissioner's office and say, this is the way it will go from now on, but because it would at least give them the opportunity to be involved and consulted in a way that they never have been before, Mr. Speaker. And I think that's why so many RCMP members were so excited and joyful when the Supreme Court ruled that it wasn't right, and it was a violation of their charter rights, in fact, that they be denied the right to bargain collectively in their workplace. And the way that the Supreme Court made sense of that was that, people need the freedom to be able to meaningfully advocate for their concerns within the workplace. And it's been our position all along that these exclusions don't do that, Mr. Speaker. And it's sometimes the case that in arguing for the exclusions, it seems to be the case, Mr. Speaker, that some members are of the view that somehow if you took away the exclusion, suddenly, a clerk in the RCMP is going to be dictating to the commissioner what the rules of the workplace are. And of course, for anyone who has any real understanding of collective bargaining, that's ridiculous. I don't see why we wouldn't want to empower members to bring forward proposals about the way things ought to operate in the RCMP. We all know, and we've discussed many times already, just in this Parliament, Mr. Speaker, let alone all the parliaments previous, that there are problems within the RCMP. And that traditionally the way to deal with those problems has been that the commissioner and the government in some way, shape, or form get together. They say that there's zero tolerance for the kinds of problems that exist, or they affirm their support for the force, and they say they want to work together to make sure that RCMP members have everything they need. But we know that that hasn't always worked, Mr. Speaker. I don't see how that could possibly be controversial to say. Collective bargaining, which the court has said RCMP members have a charter right to, would be not the only tool. And I don't think anyone is maintaining that once collective bargaining comes to the RCMP, there will be no further problems, that there won't be incidents in the workplace. But what we are saying is that introducing meaningful collective bargaining, and by meaningful collective bargaining, I mean collective bargaining without the list of exclusions that's currently in C7, we would be introducing a genuinely new tool in the workplace, not just for workers, but also for management and for government, to deal with some of those issues and to deal with those issues closer to where they're happening so that they don't have to come to Parliament in order to be dealt with, mostly by people who don't have experience or background in the RCMP, but can be dealt with in the workplace. Now, if it turns out that some of those proposals are completely unreasonable, well, Mr. Speaker, they go to binding arbitration. And that arbitrator is required by this very law to take into account the unique role of the RCMP as a national police force. It's required to take into account the stated budgetary policies of the government. And so allowing RCMP members to come forward with proposals, I don't think is any kind of real threat to the operational structure of the RCMP. Any of those proposals are first going to be reviewed by management at the bargaining table. And if they're really unreasonable, they're not going to be agreed to. And then, beyond that, they're going to be assessed by an independent third party that has to take into account all those very factors that members have so well articulated that makes the RCMP different. And certainly if you talk to RCMP members themselves, the ones who are advocating for a more open model of collective bargaining without the exclusions, they will tell you they don't want the RCMP to be treated just like any other federal department. But if you take the exclusions out, the RCMP is still not treated as just any other federal department. So it's our submission, Mr. Speaker, that C7 satisfies the legitimate concerns made in those arguments, and those arguments are mistakenly applied in favor of having an itemized list of exclusions when those concerns are already answered by the many other elements of protection, you could say either for management or you could say for the unique nature of the RCMP. Sometimes those are harder to tell apart than at others, but we're satisfied that those protections exist and that unreasonable proposals that don't adequately care for the spirit of the RCMP and its unique operational nature will be dispensed with through binding arbitration and those interpretive constraints. So what the exclusions really amount to is just prejudging the reasonableness of proposals that employees may bring and saying in advance, whatever it is you want to bring here, you can't, and we don't want to hear it. That's the tone that is set. And there may be other avenues that they can bring those proposals forward through. There have been other avenues over the last 4 or 5 decades and more, Mr. Speaker. But the point is that those other avenues haven't been satisfactory. That's why so many members of the RCMP took the RCMP to court to say we want collective bargaining, because our legitimate desires and goals within the workplace, even though it would be nice if they were, are not being heard adequately through these other avenues. So we want another avenue called collective bargaining, not because it's a panacea, not because we're going to get everything we want, but because we clearly need another tool in the toolbox. We need another way of working on these issues in our workplace in order to get the success at resolving long-standing issues within our institution that has eluded us through all those other avenues. And it's their way, I think, of asking the government not to just create more avenues that formally are the same as the avenues before and before and before, but to do something genuinely new, to let them in on the ground level to propose and be part of solutions in their workplace, and deal with as much as you can, as close to the work, if you will, Mr. Speaker, as you can. And those other issues that can't be resolved can then bubble up and can be dealt with those other issues. And I just don't see why that doesn't sound like a good idea to the government, Mr. Speaker, and why they insist on maintaining these exclusions. I just don't see the same threat to the institution. And I think anyone that looks at the bill and considers the history of the RCMP and listens to what RCMP members would have to say, and unfortunately, more Canadians aren't in a position to be able to do that directly. That's been part of the honor and privilege of being the critic for this bill for the NDPs. I've had the opportunity to do that. And when you lay those things beside each other, it's hard not to feel that this list of exclusions really is just ridiculous. It either comes from a desire to satisfy RCMP management as opposed to the frontline workers in a way that I don't think makes sense or is appropriate for government, or it comes just from a basic failure to understand collective bargaining. I mean, that's not where I started out in terms of my thinking on this, but I just don't see how you could engender the kind of resistance to these exclusions, given everything else that's in the bill, given the binding arbitration system and the interpretive constraints put on the arbitrator, to think that somehow the RCMP is going to fall apart if members who care deeply about the institution, Mr. Speaker, and that's something that has been very, very clear to me in the correspondence that I've received from them, would put on the table. So let them bring the proposals, let them work with management, let them have their agreements and disagreements, and what doesn't get solved there, then we can look at those other avenues. No one's saying those other avenues need to be closed. It's just to say that there's an opportunity here to do it differently and to do it better, and that you can do that while respecting the unique nature and therefore unique needs of the RCMP. In fact, a lot of that is already in the bill, Mr. Speaker. We've heard, just to address some of the other arguments that have been made, Mr. Speaker, you know, that it's a different kind of organization, because you start out as cadets, and anyone who ultimately ends up wearing the commissioner's uniform wore the other uniforms on the way up. And so there must be a level of trust within the senior leadership of the RCMP. That is a nice picture, Mr. Speaker, and I'm sure that it's true in many cases. But it's clearly not enough, just in the way that collective bargaining on its own isn't enough. You don't end up, just because you have a collective agreement, it doesn't mean that you never have another workplace incident, but you set up rules in order to be able to deal with it when it happens, Mr. Speaker. The kind of trust and camaraderie within the RCMP is a good thing, and I'm sure that in certain cases that has meant a great deal to those members and has helped resolve situations, but it clearly hasn't resolved them all, Mr. Speaker. And I think it verges on naive to expect that simply because people were together in their initial training that somehow 20 years later there's never going to be problems between management and workers, or that sometimes, despite their best intentions, management is going to be on the wrong side of that argument, Mr. Speaker. What's important then, when that trust breaks down, as it has demonstrably within the RCMP sometimes, is that you have a good process in place, and that's the idea behind the collective agreement. You can have workplace processes in place without a collective agreement. Many workplaces do, but the idea is to give RCMP members a say in what those procedures will be. And it's not to say they're going to get a veto on every workplace procedure. It still has to be negotiated. It still has to go through binding arbitration. So, I mean, I just, fundamentally don't agree with the idea that somehow there's something that's really going to fall apart if members are just allowed to bring those proposals. And when you hear from as many members as I have that are distressed and upset at the fact that those proposals won't be able to go forward, and they weren't consulted in any serious or meaningful way prior to this. There was the survey that the Conservatives ran, not the summer, not this summer, but obviously last summer. That was it. It was a survey. I've heard from certain members they didn't really know what they were being consulted on, or felt that they really understood what their answers would ultimately mean. So there hasn't been a great consultation, except what I've been hearing is that they don't agree with those exclusions. So I don't see why the government is willing to dissatisfy so many RCMP members, many of whom were part of that suit in court, that felt that they were gaining not a panacea, as I've said, Mr. Speaker, but an important tool in their workplace that wasn't there before, and a workplace where some things definitely weren't going right, when there's not much at stake, in my view, with removing these exclusions. So that's been something that I've been wrestling with. I wrestled with it at committee. We wrestled with it again at report stage, where we had an amendment about the exclusions that wasn't as comprehensive as the NDP amendment in committee, but at least dealt with one of those exclusions, and so we heard the same arguments again, and we've been hearing those same arguments again today at third reading, Mr. Speaker, and it's been, I would say, just a bit of a disappointment in terms of process, because other than the RCMP commissioner himself and some top brass at the RCMP, and some members, other members of this chamber on the government side and in the Conservative Party, I haven't heard anyone say that they agree with the exclusions, or that they don't think that at least some of those exclusions should be lifted. There seems to be, I mean, it's rare that you get a unanimous conclusion, and I'm sure there, and I have heard from some who think some exclusions are warranted and maybe others aren't, but the resounding cry that I've heard, Mr. Speaker, from those who are going to be affected by this legislation is that they'd like to have a significant amount of those exclusions removed, and in most cases, all of them, so that they can bring proposals forward. And I just have yet to hear what I think is a compelling argument when you look at the whole bill and the other aspects of that bill to say that we shouldn't be doing that. And I don't think saying, well, RCMP members all went to their first training together, so we should just trust them to do a good job is sufficient. I don't think it's enough to say, well, they're getting independent and they're getting independence and choice of a bargaining unit. I don't think that's enough to say when there's not much left to bargain, Mr. Speaker. I think that's a really important thrust of the Supreme Court decision that's clear enough if you read it. It's not on the list because it's the subject of the decision, Mr. Speaker. And so one might forgive the court for not feeling that they had to put it on the list of things that the legislation had to satisfy. The point was, how do you select a bargaining unit if the legislation that grants the right and the process to select a bargaining unit takes away everything you can bargain at the same time, or just about, leaving only pay and benefits? Then I think it's clear that the spirit of the decision is not being respected, and we can expect to see it challenged again by the very same people who fought it for a very long time. So we started out by supporting this to send it to committee, in part because we wanted to see those exclusions dealt with. That simply never happened, Mr. Speaker. And in all of that, I never heard a really compelling argument for why they wouldn't be removed. And as a result, it's unfortunate, but it's not something that we can support at third reading at the end of this process, Mr. Speaker. Thank you.
Questions and comments? The honourable member for Vancouver Quadra.
Thank you. Thank you, Mr. Speaker, and I want to thank the member for his work on this issue. On Bill C7, and I just want to, he asked a question about the exclusions, and so I'm going to just answer that before asking him another question, and that is that the Bill C7 actually aligns the RCMP, Labour Relations and Collective Bargaining, with the rest of the public service. And so it has exclusions that apply to other public servants. And what works well is that there are other avenues established in statutes where employees can pursue their interests and objectives in collective bargaining. And it is far more than just pay and benefits that is included. There's a whole host of other issues. So what I would really like to hear the members' thoughts on the issue that was raised by the member from Durham in the last half a minute of his speech. So he supported everything about Bill C7 until the last few minutes of his speech and then pulled his support, walking away from the constitutional rights to appropriate collective bargaining, turning his back on RCMP members on the issue of card check versus secret ballot. And so the member is very aware that the board has the right to apply the secret ballot should they think in any way there's uncertainty as to what the card check method has produced in terms of the intentions of the members, and can and will have a secret ballot if it's needed. And so could you explain your position? Could the member please explain his position around the certification and decertification, and any attempt to help me understand why the Conservatives would walk away from this entire bill on that issue? Thank you.
Honourable member for Elmwood-Transcona.
Well, thank you to the Honourable Parliamentary Secretary for her question. She gave a two-part question, so I'm going to give a two-part answer. What I would say is that, we have heard from RCMP members, and we've heard from a number of members in this place, that it wouldn't make sense to treat the RCMP just as any other branch of the federal public service. What I would say is that the appropriate analogy here is other police organizations in Canada. And at committee, we received a document that showed that there are clearly a number of police organizations across Canada, all of whom enjoy the right to collective bargaining, have a bargaining unit, that have negotiated some clauses, small or large, within their collective agreements that cover the areas of exemption. So I actually would agree with RCMP members and arguments made in this chamber that there is a unique nature to the RCMP. It certainly sets it apart from other federal departments and has to do more with policing, and that's why it makes sense to align this act more with what's the status quo for other police forces in Canada and not with other federal departments. What I would say on card check, we've heard the arguments, what are really arguments against card check. I don't believe that card check is undemocratic. I think that, it's never been implemented without an option to call for a secret ballot vote. So the idea to say that right is being taken away is just not true on the facts, Mr. Speaker. And there's a lot of evidence. If you don't make your assessment in a vacuum, there's lots of evidence that shows that the reason why, when it comes down to secret ballot votes, often isn't simply that members get to express their true opinion and it happens not to be for unionization. It's that there are intense intimidation campaigns leading up to secret ballot votes that cause employees often to change their mind, and that's why the card check system was brought about. And nothing on the facts about that has changed, despite protestations from certain Conservative members of the House.
Questions et commentaires, questions and comments. The honourable member for Timmins James Bay.
Mr. Speaker, I listened with great interest to my honourable colleague. One of the things that concerns me about this bill is that the government is purporting to respond to the court ruling about the rights of RCMP officers that have been denied in their inability to undertake collective bargaining. So we have a bill that sets out to allow collective bargaining, but then strips away key provisions that should be in place in normal collective bargaining. For example, the issue of being able to talk about staffing in terms of whether or not a police officer has backup. These are fundamental health and safety issues that would normally be under collective bargaining. The issue of harassment. We have seen so many cases of officers subject to harassment and not having a proper dispute mechanism. The Liberals are telling us there's many other existing processes that they could take the harassment claims to, but they have failed. And I think today, on a day when a RCMP officer who had 27 years of duty has been terminated, who's suffering PTSD from which she's referred to as systemic harassment on the force, that would it not be wise to allow collective bargaining to be one of the places that could put these issues on the table to start finding solutions so we don't end up in issues before the courts in terms of RCMP officers who may suffer in unhealthy work environments?
The honourable member for Elmwood Transcona.
Thank you, Mr. Speaker, and I thank the member for his question. If you look at the kind of flashpoint incidents, or if you look at the cases that the RCMP members and the MPPAC and those who have advocated for collective bargaining for the RCMP for a long time and undertook to take the RCMP to court, or the government to court, in order to secure those rights, they're not talking about, 5% over 4 years. They're not talking about little adjustments to their health plan or to their pension. That's not what they're talking about. They're talking about the kinds of incidents that we've seen and heard in the media. They have to do with harassment. They have to do with officers answering calls alone in remote and northern communities and ending up hurt or dead. They're talking about the equipment that they haven't had in some cases in order to be able to respond effectively that has ended up in the injury or death of members. Those are the things that animated and motivated a court battle over many years in order to win those rights. And I have a lot of sympathy for members who are feeling angry and frustrated that the very bill that is supposed to bring that collective bargaining regime into existence for them at the very same time takes away their ability under that regime to raise those very issues that animated and maintained and motivated that court battle over so many years. So yes is the short answer to that question. It's just not right that they're not able to bring proposals to the table. No one's saying collective bargaining fixes everything, but we are saying, and what the court has said, is that Canadians have a right to it, and that it is another way to address problems. And I think it's fair to say that the RCMP is in need of a new way, because it's tried things under the old model many, many times before. I'm glad to see we're going to try again, and I hope it's successful. But I would say that we can increase the odds of success by putting more tools in the toolbox, Mr. Speaker. And that's what meaningful collective bargaining would do, and that's not what's in Bill C7, unfortunately.
Questions and comments? Questions et commentaires?